Colorado has a clearly regulated late fee framework that was significantly strengthened by recent legislative reforms. The governing law is found in the Colorado Revised Statutes Title 38, Article 12, along with specific provisions enacted through recent tenant protection legislation. If you're a landlord or tenant in Colorado, the late fee rules have changed substantially in recent years, and compliance with the current framework is essential. Let's start with the key provisions. Colorado now caps late fees by statute. Under the recent reforms, the late fee cannot exceed the greater of $50 or 5% of the amount of the late rental payment. This creates a structure with both a floor and a percentage cap. On a $1,200 rent, 5% is $60, which exceeds the $50 floor, so $60 is the maximum. On an $800 rent, 5% is $40, which is below the $50 floor, so $50 is the maximum. This means the minimum maximum fee is $50 regardless of rent level, and the percentage only matters when 5% of the rent exceeds $50, which happens at rents above $1,000. For Colorado's typical rent levels, $1,200 to $2,200 in the Denver metro, the 5% calculation usually controls. Colorado mandates a grace period. Under the reformed statute, the landlord cannot charge a late fee until the rent is at least 7 days past due. If rent is due on the 1st, the late fee cannot be imposed until the 8th. The 7-day grace period is mandatory. The lease cannot shorten it. The combination of the 5% cap and the 7-day grace period creates a moderately restrictive framework. Colorado's approach is more regulated than states with no cap and no grace period, but less restrictive than states like Massachusetts or Maine with very long grace periods and very low caps. Colorado's recent reforms also specify that the late fee must be described in the rental agreement. The lease must state the fee amount or formula, the 7-day grace period, and the conditions for imposing the fee. A late fee that isn't documented in the lease is not enforceable. Colorado's reforms addressed compounding as well. The landlord cannot charge more than one late fee per late rental payment. No daily fees, no weekly fees, no escalating penalties. One fee per late payment. That's it. This anti-compounding provision is clear and absolute. The reforms also addressed partial payments. If the tenant makes a partial payment, the late fee is calculated on the amount that remains unpaid after the partial payment, not the full rent. If rent is $1,500 and the tenant pays $1,300 within the grace period, the late fee is 5% of the $200 that's late, which is $10. Since $10 is below the $50 floor, the landlord can charge $50, but the fee is capped at 5% of the late amount or $50, whichever is greater. The interaction between late fees and the eviction process in Colorado has also been reformed. Colorado now requires landlords to provide a 10-day notice for non-payment of rent before filing for eviction. The amount demanded must be accurate, including only compliant late fees. Including non-compliant fees in the demand creates grounds for challenge. Colorado's eviction reform also created new protections for tenants, including requirements for the landlord to provide information about rental assistance programs in the eviction notice. The overall framework reflects Colorado's shift toward stronger tenant protections, and late fee compliance is one piece of that broader picture. Whether late fees can be included in the 10-day notice depends on how the lease defines them. If defined as additional rent, they can be included. If not, the landlord should demand only the unpaid rent. Best practice: define late fees as additional rent. Colorado's Consumer Protection Act, found in CRS Title 6, Article 1, prohibits deceptive trade practices, systematic overcharging of late fees beyond the statutory cap, or charging fees before the grace period expires, can constitute a deceptive practice. The Act provides for actual damages, treble damages, and attorney's fees. This creates meaningful risk for non-compliant landlords. Colorado limits the security deposit to an amount agreed upon in the lease. There is no specific statutory cap. However, the deposit must be returned within 30 days, unless the lease specifies up to 60 days. the landlord must provide an itemized statement of deductions. Unpaid late fees can be deducted if compliant. Failure to return the deposit within the required timeline can result in the landlord being liable for treble the amount wrongfully withheld, plus attorney's fees. Colorado's treble damages provision for wrongful deposit withholding makes clean late fee calculations particularly important. A $50 non-compliant deduction becomes $150 in liability, plus the tenant's attorney's fees. For tenants receiving Housing Choice Voucher assistance, Colorado landlords should not charge late fees when the Housing Authority's portion is delayed due to processing. Colorado prohibits source of income discrimination in several jurisdictions, including Denver and Boulder. Penalizing a voucher tenant for the authority's processing delay can create both a late fee violation and a discrimination claim. Colorado's military population is centered around several installations: the United States Air Force Academy near Colorado Springs, Fort Carson near Colorado Springs, Peterson Space Force Base, Schriever Space Force Base, Cheyenne Mountain Space Force Station, and Buckley Space Force Base near Aurora generate significant military demand across the Front Range. Fort Carson, home to the 4th Infantry Division, is one of the largest Army installations in the country and generates massive rental demand in the Colorado Springs area. The Space Force and Air Force installations around Colorado Springs create additional demand from a professional military and civilian workforce. Military pay is predictable, and most military tenants pay reliably. The 7-day grace period comfortably accommodates any pay processing delays. SCRA protections apply to active duty service members. From a practical standpoint, Colorado's rental market has experienced dramatic growth, particularly along the Front Range corridor. Denver is the state's dominant market, one of the fastest growing in the country over the past decade. The economy is driven by technology, aerospace and defense, healthcare, energy, financial services, outdoor recreation industry, and a strong startup ecosystem. Rents in desirable Denver neighborhoods, Lodo, Rhino, Capitol Hill, Highlands, Wash Park, commonly range from $1,600 to $2,500. The 5% cap produces maximum fees of $80 to $125. Most Denver landlords charge at the statutory maximum, 5% or $50, whichever is greater. With the 7-day grace period, the professional tenant base generally pays on time. Late fee enforcement is routine but limited to a small percentage of tenants. Denver's recent tenant protection reforms have been among the most aggressive in the Mountain West. The city has been at the forefront of landlord-tenant regulation, and landlords in Denver should monitor ongoing legislative and local developments. Boulder has a tight market driven by the University of Colorado, the technology sector, and outdoor lifestyle appeal. Rents are among the highest in the state. Boulder has enacted source of income protections and other tenant protections. Student late payments correlate with financial aid processing. The 7-day grace period covers most delays. Colorado Springs has a market heavily influenced by the military and defense sector. Fort Carson, the Air Force Academy, Peterson, and Schriever generate enormous demand. The combination of military BAH and defense contractor salaries creates a reliable tenant base. Aurora, Lakewood, Westminster, Thornton, and other Denver suburbs have strong markets with moderate to high rents. The suburban markets generally follow Denver's late fee framework. Fort Collins, home to Colorado State University, has a tight market with student demand. Pueblo has a more affordable market. Grand Junction has a moderate western slope market. The mountain resort communities, Vail, Aspen, Breckenridge, Steamboat Springs, Telluride, have extreme housing costs and severe workforce housing shortages. Service industry workers in these communities earn seasonal wages that may not align with the high rents. Late payment patterns among resort workers may correlate with tourist seasons. The statutory cap limits the late fee regardless of how high the rent is. 5% of a $3,000 ski town rent is $150. One best practice for Colorado landlords: comply precisely with the reformed statute. The cap, $50 or 5%. Whichever is greater. The 7-day grace period, the 1 fee per payment rule, and the partial payment calculation are all specific and testable. Set your accounting system to enforce these rules automatically. Colorado's tenant advocacy organizations, including Colorado Legal Services and the Colorado Poverty Law Project, are aware of the reforms and will hold landlords to compliance. Another best practice: never charge a late fee before day 8. The 7-day grace period means the earliest possible trigger is day 8. Build a 1-day buffer. Charge on day 9 to eliminate any calculation errors around weekends or holidays. A third best practice: calculate the fee on the amount actually late when a tenant makes a partial payment. If a tenant pays most of the rent on time and a small remainder late, the fee applies to the late portion, not the full rent. Getting this calculation right demonstrates compliance and prevents disputes. Track partial payments carefully in your accounting system. For the complete guide to Colorado late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.